it to you people. As you might be aware, each time you sit before us or any other committee, you are protected under Cap 12 of the laws of Zambia, which grants members of parliament immunity against prosecution for what they say while in the house. This means that the information you give to this committee cannot be used against you outside parliament or indeed in any court of law for as long as it is factual. However, should you deliberately or willfully mislead or misinform the committee, the same law can be used against you in the courts of law. I have no doubt in my mind, however, that this won't be necessary, as you won't choose to willfully mislead or misinform the committee. You may now proceed to make your submission. Thank you.
Much obliged, Chair, and thank you very much for the immunity. We, as the Law Association of Zambia, firstly, would like to thank this Honorable House, the National Assembly of Zambia, for extending the invitation for us to participate in this important topic, which regards the law of our land. So we'll go straight into it. The committee will note that from the onset, the last execution in this country, in Zambia, according to our research, happened in January of 1997. That was the last time somebody was actually executed in this country. So this goes to show the reluctance by the executive branch of government to carry out executions. Successive presidents, starting from President Chiluba, President Mwanawasa, and all the other presidents that came after, inasmuch as the death penalty was available in our statutes, we're not signing death warrants. So, as it stands, this House might be aware that the Penal Code, Chapter 87 of the Laws of Zambia, was amended last year in 2023 by Act number 23. Act number 23 of 2022. Sorry, that's 2022, not 2023. I beg your pardon. And this presented amendments to the Penal Code. Essentially, sections 24, 25, and 201 of the Penal Code were amended to the extent that the death penalty, which was previously applicable to offenses like aggravated robbery, murder, and treason, was removed through an act of parliament. Now, that shows that this country is on the way or in step with the international obligation of abolishing the death penalty. However, Article 12, I think the Honorable Committee might be aware that our Bill of Rights, we failed to amend the Bill of Rights in 2016 during the referendum. So the Bill of Rights still remains the way it was, despite the Constitution being amended in 2016. So now there's a problem now in that Article 12.1 of the Constitution still makes it possible for a court in this country to pass the death sentence. Okay? Whilst the Penal Code was amended to do away with the death penalty. So now, the Constitution is the supreme law of this country. Okay? So, that inconsistency between the Constitution and the Penal Code is something that needs to be resolved. Now, our submission as LAS is that ratifying the second optional protocol to the ICCPR, which abolishes the death penalty, while Zambia has already abolished the death penalty through the penal code, we have not done the constitutional amendment. So there's a chance that the death penalty might return in future. So if we ratify the second optional protocol, one of the key features of the second optional protocol is that state parties must ensure that they abolish the death penalty and also ensure that the death penalty does not return. So that is the key part, that Zambia needs to ratify this protocol to ensure, or as a safeguard, that it does not return back into our statute book, because this parliament has abolished it, but there's no guarantee that another parliament in future might not bring it back. So how do we sort this out? Firstly, by ratifying this protocol, then Zambia as a country becomes bound at international level to try and bring its statute book in line with that protocol. Now, that would entail a constitutional amendment to affect the Bill of Rights, to change the Bill of Rights to bring it in line with the second optional protocol. So as a starting point, our submission is that it would be good for this country if we ratify that protocol, because at international level, through the peer review mechanism, we will be bound to put in measures through our statutes, which is in this case the Constitution, because the Constitution is the only one which is remaining, which is not in line with the ICCPR and the second optional protocol if it is ratified. So LAV's overwhelming submission, or LAV's firm submission before this committee, is that this House should ratify this second optional protocol. Thank you.
Thank you so much for the brief presentation, which is comprehensive. Honourable members, here we are. I think it's time we can try and inquire more from the witness.
Jawali is where at some point the Parliament may decide to bring back the death sentence. Further, according to the Constitution, there is no amendment. It is still pointing to a law that does not exist. Now, my question to you, does that constitute to being a lacuna? Secondly, the last execution was in January 1997, and that execution was in tandem with the Constitution and the law that we abolished. However, from 1997 to date, no president has ever authorized the execution, even when the law allowed. My question on that is, being a lawyer, a learned, and a technocrat in this law, did the past presidents who did not act according to the Constitution and then the law that allowed the death penalty abrogated the law?
Honorable Fube, you can pick two. I think he's got two concerns, then I think he's got one, then you pick the three, then you go for the next round.
My concern is on the second protocol. Let me take you to page 2 of your submission. Last paragraph, which says, importantly, Article 6 of the protocol prohibits reservation for death penalty in terms of war for serious military offenses. As we think of, acceding to this protocol as a nation, we know that there's Article 12, which has an exception, and this Article 6 is prohibiting such exceptions. But on the other hand, we have also abolished death penalty from the military, the Defense Act. I'm sure you know all that, from the Defense Act. And yet this Article 6 is leaving that particular leverage that for death penalty in times of war for serious military offenses, meaning that in a way, if we were to take on this second protocol, it would be also sitting well that we obey anything that is suggesting, meaning that even our local laws should take on board, maybe using the Defense Act, to have that proviso that in terms of war and serious military offenses, that can be taken on. I don't know, since we have also removed it from the Defense Act, we have also removed it from the Penal Code. What is your comment, especially specifically on the Article 6 of the protocol, as it applies to the surgery that we have done to our laws? Thank you, Chair.
You can go ahead and attend to those three concerns.
Thank you very much for the questions, honorable members. My mic is off, sorry. So, the first question was whether there's a lacuna or not. It's a very famous word, lacuna. So, I would say yes, there's a bit of a gap between, because the lacuna simply means a gap. Okay, so we have a bit, there is no gap, but I would say it's a bit of a gap. I don't want to call it a lacuna, but I'll call it maybe a bit of a contradiction, or should I say an inconsistency, because on one hand the Constitution is saying that everyone has a right to life, except in the execution of a sentence from a court of competent jurisdiction. So essentially what the Constitution is saying is that the courts can impose a death sentence if there's a law that allows it, right? But right now, the law that allowed that death sentence has been repealed. So which means that there's a mismatch there between the Constitution and what the ordinary legislation is saying. So in order to fill up that void, I don't want to use the word lacuna, I don't want to be quoted, so let me call it a void.
No, if it's a gap, it's a gap. What can you do? You know, at law, you just call it, at law, just
this protocol will go a long way in triggering this House to lead constitutional reform, because the end result is that the Constitution, which is the supreme law of the land, has to be changed. Because as long as the Constitution is not changed, then that gap remains and it leaves a room for the death penalty to come back. I hope I've answered that one.
Your mic. From your submission, the worry is to have this law come back. Does it give the Constitution, does it give any room for a judge to condemn a convict to death in the current state?
No, it doesn't. Right now the death penalty is not part of our law, because the Constitution is saying that under Article 12(1), it's saying that a court can convict someone and sentence them to death if there is a law that is saying that. So previously, the Penal Code and the Defense Act, there were certain offenses that were characterized and also attracted what we call capital punishment. Okay? Now that is no longer there. Okay? So the Constitution is pointing at a law which Parliament can pass. So right now Parliament has decided that it does not want to pass a law which allows capital punishment. Okay, right now as it stands, this Parliament has said no, they have taken that law away. But the Constitution still remains as it is. So the Constitution still leaves that room. So if Parliament decides to change its mind and say, okay, you know what, we want to bring the death penalty back, it will still be constitutional because the Constitution allows it. So that's my answer to that. I hope I've answered. And then the next question was, were the presidents acting outside the law? Okay, so there's a procedure that has to be followed. Once a court passes the death sentence, which in the past was mandatory, right, for murder, if you're found guilty of murder, if there are no extenuating circumstances, then the court had to pass the sentence, capital punishment. Or if you are convicted of treason, I think we all remember the famous Shamwana case and yeah, the coup attempt and things like that. So what happens is that when there's an appeal and all the appeal processes have gone through, let's say we've gone to the last court, which is the Supreme Court, and it says, okay, the sentence is upheld, you have to hang. Then the presiding judge will have to forward to the president a copy of the record. It has to be transmitted to the president, right? And then the president receives advice from the committee on the prerogative of mercy. So when you're talking about the prerogative of mercy, we're talking about pardons, committal, right? There's a pardon and there's a committal of sentence. Like a committal of sentence is if you're sentenced to death, the sentence is committed maybe from death to life. Right. So there's a committee that sits, that advises the president on the prerogative of mercy, on which prisoners need to be pardoned or which ones need to have their sentences commuted. So if that committee advises the president that you do not deserve a pardon or you do not deserve your sentence to be commuted, then it gives the report to the president, and then the president has to sign what is called a death warrant. And then that death warrant is what, when it is executed, you are put to death. So in saying that, did the president commit a breach of the Constitution, I would say no, because the president has power to commute the sentence, to change the sentence from a death sentence to life sentence. So in most of these cases, what happened was that most presidents were not signing the death warrant and they were commuting the sentence. So they would move the sentence from death to life. So in that case, then the president hasn't breached any law because he has exercised his powers under the prerogative of mercy, which is provided for in the Constitution. So in the same way, a president can pardon a convict, like wipe away the sentence completely, the president also has powers under the Constitution to change a death sentence to a life sentence. And I believe that is what happened. I think there were 45 that were accused of trying to overthrow President Chiluba's government. I think they were convicted, and President Mwanawasa commuted their sentences from death to life, and some of them were even pardoned. So there was no breach. And then finally, the third question was, it prohibits, Article 6 prohibits reservations. So would be, if we accede to this protocol, then it means that we have to align all our laws in line with the protocol. That is correct, Honorable. Once we sign up to that protocol, it means that we are not allowed to make any reservations except that one which is to do with serious military crimes. So what it essentially means is that once Zambia signs up to that protocol, then under international law, we'll be under obligation to align all our laws, including the Constitution, to align with, to abolish the death penalty completely, and only leave space to bring it back only for military offenses. And that's serious military offenses, not any military offense. So that's what it means.
Yeah, I can go ahead. It's getting interesting.
Then confirm that we are going into this second optional protocol with an inconsistency, especially because we have Article 12 sitting in our supreme law of the land. You know, according to constitutional order, of course, the constitution is more superior than any other law. So, could you say that we are going into signing this, second optional protocol with an inconsistency on our laws?
I think just a rider before you, just a rider. Would you be comfortable to follow someone's law and leave your own in line to what others can go ahead?
Okay, I'll take the first question first. Yes, we have an inconsistency, as we have already highlighted, and Honorable Ovade called it a lacuna. Yeah, but that inconsistency is there. And as an association, we are of the view that acceding to this protocol is the first step in trying to get rid of that inconsistency, or trying to reconcile the two positions, because then it will create a necessity or a need for us to carry out the necessary constitutional reforms to bring us in line with the protocol. Then to answer the Honorable Chair's question that would we follow somebody else's law and leave our own, I would say no. As an association, we would not encourage this country to do a copy and paste of other people's laws besides our own. However, the committee might want to note that this second optional protocol is an optional protocol to the International Covenant on Civil and Political Rights, which we are already a party to. We already signed on to the ICCPR, and large sections of Part 3 of our Constitution, which is the Bill of Rights, are actually a copy and paste of that covenant. So the ICCPR is already part of our law, so to speak. It's part of our Constitution. So by signing on to the second optional protocol, we are not necessarily taking the law of others, because the ICCPR, we already adopted it as a country. We also, again, adopted the first optional protocol to the ICCPR. So it will only make sense that we adopt it as a whole, so that now we can be able to bring our Bill of Rights in line with what the ICCPR says, because this is where our Bill of Rights comes from. So just to close, I saw Honorable wants to ask a question. So just to close on that, I would say that the whole idea behind the second optional protocol to the ICCPR is that it was realized by the UN General Assembly that there was no empirical research, or there was no evidence which showed that the death penalty actually served as a deterrent against certain crimes. That evidence is not there. So without that evidence to show that when we sentence people to death we reduce crime, then it becomes some sort of inhuman treatment, because there are other forms of punishment that we can use as a deterrent in terms of preventing crime, and the death penalty has not been shown to work. So that's my answer to that.
Thank you. Before another set of questions, I just want the Member of Parliament who just joined us to introduce himself. We have got Laz on board.
Thank you, Chair. Afternoon, Laz. I'm Menyan Zuru, representing the people of Nyimba constituency in the Eastern Province. Thank you.
Thank you. Honourable members, any further. Honorable member for Mapala, please go ahead and ask your question.
Thank you so much, Chair. And thank you, Laz. Two items which I need your clarification. One is, of course, the public. I was in the Constitutional Conference in 2016. The public voted for the death penalty. And how do you reconcile your position as Laz against what the public wants? Are you consistent or you are inconsistent with what you put together as Laz? That's one. And the second one is, of course, the same failed referendum of 2016. What happens if we do all these statute things from this end, but we don't get the necessary threshold during the referendum? What are the implications? Thank you.
I think you can go ahead, Honorable for Pemba.
Thank you so much, Chair. Chair, on page 2 of your submission, Laz, you are actually advising the committee that it will be very important that since we abolished the death penalty and we are to ratify this protocol, it will be important to amend the constitution so that there will be no room, therefore, for any parliament to come, to go back and reinstate the death sentence. Now, my worry is, Laz, this is the law that we have not seen how it is actually going to serve the public, how good it is going to be, in as much as we are trying to protect the life of people. You may wish to understand that there are people out there who lost their beloved one, killed in cold blood. And we are telling them to say, look, this person who killed your brother, your breadwinner in your family, should actually just stay in prison for life. To some extent, there is also a belief that people, in as much, of course, you have indicated that there is no empirical evidence that the death penalty reduced the suspects. But then there is a belief that now people have no fear. If there is anything people fear much, it's death. But you remove that, and we want to remove the safeguard. I'll call it a safeguard myself. When the Constitution is still pronouncing, that we still call it a safeguard. Now, if we remove the safeguard, where there is no room to maneuver, and if at a certain point you do a study, a research, and it is discovered that actually after removing the death penalty, crime has increased, people are killing each other anyhow, what are we going to do if we remove this safeguard? How safe are we? Secondly, I will speak more like a sadist.
Honorable member, maybe let him respond to the two, then again you come back.
Okay.
Thank you.
I reserve that one.
We don't want to sadist here.
I'm happy that there are a lot of questions. It means that this is a very important topic, and rightly so. It's a matter of life and death, literally speaking. So the first question that came was, the public voted for the death penalty. What is your position as Laz, and are you being consistent? We are being consistent. We have always been against the death penalty. Even when the president, when Parliament passed the bill and the president assented, I think Laz congratulated the president for that as a first step towards that. As a pro-human rights, I come from the Human Rights Committee, so we're all about human rights. And are we consistent? Yes. Now, the public, yes, you said the public voted for the death penalty. I would say that research shows that opinion is split. There are some who are for and there are some who are against. And those who are against are like us, the human rights activists, and members of the public would tend to lean towards the eye for an eye kind of thing. But I would say that it is our duty as what you call as learned people, together to partner with this house, which is our National Assembly. Our National Assembly are the people's representatives, to go back to the people and educate them on why we are eradicating this death penalty. I think we put in one of our recommendations that an outreach program has to be done to educate the masses on why we are saying we resort to other means of punishment. So I'm going to answer the last part of your question together with the third question that came from Honorable here, that some people have had their relatives killed in cold blood and they would pay for the death penalty. Look, the death penalty has been with us since colonial times. It has not stopped people from killing other people. Again, the statistics show that even if we had the death penalty on our statute books, people were not being executed. Okay? Even having the death penalty there did not result in people being executed. So, when you look at this issue where you talk about relatives who having their relatives killed and they would want the perpetrators to be punishment, that is a very serious issue that goes to our soul as a nation. We call ourselves a Christian nation, number one. We don't need to condone the heinous crimes that are committed by people. But on the other hand, it does not mean that us also as a state, we should also do the same thing. Okay? Secondly, the day we moved or we changed Zambia Prison Services to Zambia Correctional Services, it also adds in now to say, maybe let me backtrack a bit before I come and bring it together. In law, in criminal law, when you're talking about theories of sentencing or principles of sentencing, there is a retribution side which seeks revenge, and also there is a reformation side which seeks to correct the perpetrator. So when we changed our system from Zambia prison,
and the third one,
there's retribution, rehabilitation, yes, rehabilitation, and
the third one,
reformation. Okay. 3 R's. So those are my first year in the criminal law, but I still remember. Yes, those are the principles of sentencing. So you choose which one you want to pursue. Even as a country, you entrench it in your statute book. Okay, so when you are coming from a colonial system was more on the retribution side, because this was a minority kind of government which didn't care about the human rights of the majority who are citizens. Now here we are, where we are saying we've amended our constitution, and Article 267 we are saying the constitution should be read in such a way to promote the human rights of citizens. Whether they are criminals or not, they still have human rights. And also I was saying that we have changed our system from prison to correction. So which means our thrust as a country is we're trying to correct. Now my argument is that you cannot correct someone by killing them. That does away with the correction, because killing someone is not a form of correction. It's not. They are dead. They haven't been corrected. But if we are saying that we want to reform these people, we want to rehabilitate these people, then there will be no place for the death penalty in our statutes. And then finally you say that this is a safeguard as to whether we want to bring it back in future or not. So my answer to that is that as an association, as LAS, we feel that we have come to a point where as a country we have to decide where we are going. Are we going against the death penalty completely? If we are going to choose that direction, then that's it. We can't do one leg in the water, one leg in the fire. If we decide we are going to do away with it, then let's do away with it. We'll deal with the consequences of that, because that's a choice we've taken. And then the issue was, what if we fail to get consensus like the last referendum? I think all of you honorables here will agree with me that the referendum last time failed because as a nation we made mistakes, and I'll say we because I'm part of the country. We made a mistake in putting an important national thing like a referendum during a political event. And I'm saying a political event in that elections, whichever way we look at it, are a partisan political event. And it was a big mistake to put an important document like the referendum together with elections. So in order for us to get consensus next time we're holding a referendum, as an association we believe that it should be held outside the election cycle. Because if it's not tied to elections, elections are competitive in nature, and a referendum is not necessarily something that is competitive. Because in a referendum you seek consensus from both sides, opposition, ruling party. A referendum is for everyone. In short, it's for the whole country. So if we're going to bring people together, then our referendum should not be held at the same time with an election. Only then are we able to rally the numbers to the people, because everyone, all of you MPs, you stop politicking and focus on what is on the table, because your seats will not be at stake and there will be no election at stake. People will look at what it is.
Okay, thank you. I think due to time, unless there are really thorny issues, we probably can be referred to our next witness. However, I just want to put up just one question to yourselves. I don't know whether we call it, at law, sustainability of laws. I don't know. I think we understand the term sustainable, where we are doing that which we need to do today without, So if you look at the genesis of this, we were not there when they framed these, human rights. And if you look at our constitution, it's both rigid and flexible. Rigid in a sense, in a manner that the difficulties through which it can be amended, and the flexibility, the easier through which it can be amended. Now, there are two pages here. This which we are being, we are discussing here is in the difficult. Why then did the framers or the Zambians put this in a difficulty category, which will involve each and every Zambian into, if we were to follow the, coupled with the, if you look at the way it's framed, protecting life except is covered. There can be death imposed, there can never be death imposed. So looking at the two, is this law that is being populated to be amended sustainable? I submit.
Yeah, my question, Laz, is in your own thinking, as a technocrats, do you think this move of abolishing the death penalty is good for a poor country like us, bearing in mind that keeping people who may not be productive is a huge cost to a country?
You can attend to those two, then we wind up. Thank you.
I'll answer the chairperson first. You asked as to why it was put in the rigid part of the constitution and whether this amendment we're trying to seek is sustainable. So first, to say why the right to life was put in the rigid part of the constitution, it's very simple. Because the framers of the constitution felt that the human rights need to be protected against arbitrary changes, or maybe what we can call the arrogance of numbers or elected dictatorship. So it's it's actually a good thing in that for us to change the things that affect.
The term that you have used, elective dictatorship. Elected. I don't think he who is elected can be a dictator. A dictator comes in a different form, and he comes with his own without being elected.
Well, that's a term we use in constitutional law. It's actually a term that it is possible to have an elected dictator, but that's a story for another day. I will need to come and I would be glad to give that lecture. But yes, I am a lecturer, but at the University of Zambia and at Copperbelt University. Yeah. So the idea behind entrenching the Bill of Rights is because you want the Bill of Rights is the most important part of the Constitution, actually. That's why it's protected, because it speaks to all of us, our rights, right? So the reason why you entrench it and you need a referendum to change it is so that it is not bulldozed by political interests. But for you to change it, you need to get national consensus across the board from everyone. That is the idea. That is why it's so important that this is done correctly. Now, you asked to say, is this sustainable? I would say yes. Because for the simple reason that I'm a constitutional scholar, by the way. So now, if you leave the Constitution open to say the death penalty can come back, okay, for starters, I'm a huge critic of our Bill of Rights as it is right now, because it's giving with one hand and taking with the other. So if you look at most of the articles in the Bill of Rights, you'll find you have a right to this, and then there are 13 derogations against one right. For me, that is not right. If you are giving a right, just give it. Okay, if there are exceptions, maybe there should be one exception or two exceptions, not 15 exceptions to one right. That doesn't, to me, it doesn't sit right. So, is it sustainable? My answer is a categorical yes. If you leave the Constitution open like that, to say, okay, we should be able to bring the death penalty when it comes, fine. Because the Bill of Rights is saying that the death penalty can be applied when there is a law that says that. So what if one day we have a crazy parliament, I'm sorry to use this word, we have a crazy parliament, and the parliament just decides that anyone who passes a red traffic light will be sentenced to death. It will still be a law, and sentencing people to death will not be unlawful, because we've left it like that. So what we are saying is that let's close that loophole. Okay, the reservation is saying let's reserve it only for serious military offenses, and that makes sense because serious military offenses involve crimes against humanity, war crimes. These are crimes that ordinarily involve the taking of life on a large scale, right, or torture and things like that. But if you leave it to say any law can be used to pass the death sentence, then we don't know which human beings we are going to have in future, and they're going to turn around and say
that's why I asked a question which you never answered when I said, why should we abide by someone's law and leaving ours? There it is, the protocol has got exception. But why do we want to look at our local exception, ignore our local exception and subscribe to the international exception? That was my question, which you never responded to. But anyway, you can go ahead.
Because we are part of the international community. and we already signed on to the ICCPR. So yeah, that is our position, and we feel that we cannot take the chance of leaving it open for it to come back in whichever form, because we don't know in whichever form it will come. Next time we'll be told that theft attracts a death penalty, and there's nothing we can be able to do about it because the Constitution allows it. But if the Constitution completely does away with the death penalty, then we know that it will never come back in whatever form. If you want, you can impose a sentence of 50 years, it's still fine as long as you're not imposing a death penalty. And then, is the move to abolish the death penalty good for a poor country like us? I think so. Because I would say that, like I said, that 1997, I was very young. I think I was in grade 6. No one has been executed since 1997, and a lot of people have been sentenced to death since that time. So either way, with the death penalty on our books, we were not executing these people, which was an expense on our government. And it's very expensive, and our prisons are overcrowded. This is a notorious fact. So maybe doing away with the death penalty will actually work in the reverse, because if you know that there's no death penalty and people who are committing these capital crimes are sentenced maybe 25 years, 30 years, they know one day they're going to come out. But then it goes on a sliding scale, because then,
which is still a cost.
Yes, it is a cost, but I was trying to make a point that on a sliding scale, it means that we have to review our entire statute book, because there are certain offenses that people are being sent to prison for stealing 2 chickens. They're sentenced to 2 years in prison. I think that is overcrowding our prison. We need to look at a situation where crimes are characterized according to their severity, and if we're going to reform people, those who commit minor offenses, we might look at things like community service, and so that they serve the government and become productive, instead of just piling them up in prison.
Thank you so much. And looking at time, we still have your colleagues waiting for us outside. I think we could have continued. I think there are others that are waiting outside, and we would want to thank you for your submission, which we won't take for granted, and the committee will look at it together with others. Then from there we'll have something that will be able to present Parliament. Otherwise, we thank you and we'll call again.
We thank you, Chairman.
Yeah, before I leave you, remember that which I gave you, the immunity. Normally we are so mean, wish to withdraw the immunity, so that as you go without them. I thank you.
Thank you very much, Chairperson, and we hope to be invited next time. I don't have immunity, so I can't talk too much now.
My e-Parliament mobile application. My e-Parliament is a mobile application developed by the National Assembly of Zambia in order to bring Parliament closer to you. You can download and install My e-Parliament from App Store or Play Store. Once installed, you can raise your concerns, provide your input, opinion and feedback on various projects or decisions being made in your constituency. On My e-Parliament mobile application, you can listen to Parliament Radio. You will have access to parliamentary documents such as bills and acts which are considered in Parliament. You will also have access to National Assembly social media platforms such as Facebook, Instagram and Twitter. You can also watch parliamentary debates live on our YouTube channel. Download My e-Parliament now. My e-Parliament, bringing Parliament closer to you.
Her Honor, the Vice President's question time.
Questions for oral answer